Welcome to this Law for Community Worker webinar, 6 Employment Law Myths Busted. Before we begin, we'd like to acknowledge the traditional owners of the lands from which we are broadcasting today. I'm broadcasting from the land of the Widjabul-Waibil people of the Bundjalung Nation. We pay our respects to elders of the land, both past and present, and we extend that respect to any Aboriginal or Torres Strait Islander people attending the webinar today or watching the recording. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. This session will be an hour in total, including time for questions at the end. After the webinar, you will receive an evaluation survey and we really appreciate your feedback and suggestions for other topics you'd like to have webinars on. You'll also receive an email following the webinar with information about any resources that are referred to in the webinar today. I'll now hand over to your presenter for this webinar, Giles Fryer from Legal Aid New South Wales Employment Law Team. Welcome, Giles.
Thank you, Bridget. Thanks for that introduction. I'd like to acknowledge that I'm hosting this webinar from the lands of the Gadigal people of the Eora Nation. I pay my respects to elders past, present and emerging, and thanks to everyone so far who's entered into the chat where you're coming from. Had a quick look before we started today at who was attending, and it's really exciting to see a really kind of diverse range of workers and contractors all across community legal services and sort of related areas. So I hope this is going to be of value to you today. We do have an hour, so we'll jump into it quite soon, and I'll just go across and introduce myself a bit in a moment. So just about myself, as Bridget said, my name is Giles Fryer. I am an employment lawyer and I work in the employment law team here at Legal Aid New South Wales. We thought it would be a useful way today to talk about some myths, common myths that we deal with when we assist clients with employment law matters at Legal Aid, as a bit of a way to help introduce common employment law topics, but also some of the recent quite significant changes, both in cases that courts have decided and also in reform of legislation that the government has proposed or has already made. So in terms of a bit of a summary of today, what we'll be doing is starting off explaining a bit about our service, the employment law service at Legal Aid. We'll then be thinking about why we're busting myths, just to frame in context a bit about why it's so important to really bust these myths and provide accurate, correct legal advice to our clients in the space of employment law. We've divided the myths up into sort of 3 general categories, which are really important and very common topics that we give advice on or representation to clients. Firstly, we'll look at some myths about determining a worker's status. Are they a permanent employee or casual? Are they an employee at all, or are they a contractor, for example? We'll then deal with a myth around employee entitlements, wages and entitlements and things like that. And then we'll look at some myths, some of the more common ones around termination of employment and what rights employees have to dispute a termination. After that, we'll sort of finish up with a bit of a summary and some of the key takeaways, and then we'll look at a few useful tools that we often provide to clients if they can self-help, or otherwise that we use ourselves to assist clients, and look at some referral pathways, either to our team or else to other legal services or organisations that may be able to help with employment issues. As Bridget said, we'll have a little bit of time at the end for some questions. I will just say, with the 3 parts of the 6 myths, we're going to have a short scenario with a quiz for each one. So there'll be 3 scenarios, and then there'll be a sort of yes and no poll that you can answer in Zoom. So hopefully it breaks it up a little bit instead of me just talking the whole time. Alrighty, so Jumping through to our service, as I said, I work in the employment law team here at Legal Aid New South Wales. So just to frame where we sit within Legal Aid being a large organisation, so Legal Aid has the three major divisions of criminal law, family law and civil law, and we sit in the civil law division as a specialist team. So we provide specialist legal services in relation to employment law specifically. When we think about what types of employment legal issues we deal with, in a way it's better to think of what we don't deal with because it's very broad. So we actually don't deal with workers' compensation law or personal injury matters. And really most of the other matters in both the federal employment law system and the state employment law system we deal with. And we also deal with sort of anti-discrimination laws in the workplace. We do that in partnership with a new legal service at Legal Aid called the Respect at Work Legal Service. So we do all the things you can imagine: unfair dismissals, general protections under the Fair Work Act, underpayment of wages. If you look at the bottom, you'll see these are sort of our three major types of cases that we get clients coming through asking about. We're a team, we're a small team of 5 lawyers. And we're based in Sydney, but we do have statewide coverage. So a lot of our clients will be coming in from the regions, and that's because obviously Legal Aid has offices in all across New South Wales. And so our general civil solicitors are able, they have a lot of knowledge on employment law, but where they need assistance from our team, they'll come to us and either refer a matter or otherwise run the matter with our assistance. So we deal directly with clients. We do, as it says, 1,900 services in the last 12 months. That's primarily advice, a 30-minute free advice service for a client, but we also provide representation all the way through full court hearings if a person has a grant of legal aid. I didn't add on this slide about what type of triage criteria our team applies to determine who can get advice or assistance from us. And that's because criteria tends to change quite frequently. We sort of widen and narrow the gates depending on the volume of clients coming through, but also on capacity. So some of the things we do apply is often a income threshold. For example, at the moment, the person will be able to get advice if they earn $80,000 or less. That's different if they're getting advice about discrimination, for example, but otherwise there's also some criteria that's applied. So at the end, we'll talk a bit about if you ever in your work have a client that you'd like to refer through to us for some legal advice about an employment law issue. It's best always, to get in touch, and we can advise you about what those criteria are to determine whether your client or the person you're helping will be eligible to get some advice. Right, so thinking just today about myth busting, unfortunately, we're not going to be getting the welders out. The myths won't be as interesting as the show, the namesake, but we will be really thinking about some big issues in the space of employment law that really affect many tens of thousands of people in Australia on a daily basis, thinking about their rights when they go to work, when their work ends, or how much they get paid. Myths are really pervasive. I've said here around the proverbial water cooler. These days, that's on Teams when you're chatting with your colleagues, or it's catching up at a meeting, but we all spend so much of our lives at work, for good or for bad, and we spend a lot of time with our colleagues, and people have very different experiences either in previous jobs or at their current jobs with, for example, how they interact with HR or management about issues relating to pay or changes to their contract, asking for flexible work conditions, the whole gamut of employment law issues. And people always want to share their personal experiences, which of course is important, but often there are very different experiences and some of them haven't been legally correct. So what happens here is that you've got often an assumption about a person's legal rights or indeed their obligations. That's either from the experience they've had or even from the incorrect information they've been given by their current employer or a previous employer. And so when they have that, they don't have the full facts and they often aren't able to access their full rights. And that happens in an environment where employment law can be very technical and complex, because you have multiple layers of rights and obligations in employment law. We'll talk about it in a bit, but we have our contract of employment. There might be an enterprise agreement or an award, and then there might be a modern award, or even the national minimum wage. Then there are different laws, discrimination laws, the Fair Work Act, or the state acts. We'll get into those in a bit, but the idea is that it is complex, and then it also changes all the time. We'll talk about some big high court cases soon that have really changed the playing field in a big way, but also the governments, we've had a big change obviously in federal government and also at the state level. And as part of those changes, some of the big promises are in the space of changing employment laws, changing how things are, or rebalancing the difference between rights for employees and rights for employers. Talk more about those soon. Obviously, misunderstandings about the law in any space can have serious consequences for clients. With one big example that we commonly see is around pay in the employment law context. And that's because if a person has an assumption that they don't have a right to seek additional pay or to make an inquiry about their pay, that can lead to them not enforcing their full rights over a number of years. And then we'll often speak to them and they might have been underpaid for 10 years. And with the limitation periods in the laws, you can only claim back underpayment of wages for a period of 6 years. So really it's about being able to, when we speak to clients, to understand what their ideas are or what their understanding is of their rights, and then to hopefully be able to give them correct legal advice to fix the issue before it becomes worse. So going to myth bust, we're going to get started on the first sort of part of these, or the first category, which is myths about determining a worker's status. And this is a really common type of part about work in Australia generally that gets really complicated very quickly, and one that we often have to give advice on. And I'm sure for anyone who's giving advice out there, they've often had to ask, they've been asked by a client, am I a contractor or am I an employee? Or am I casual or permanent? So we'll look at some myths in this space. Starting with myth one. Now, the myth that we often hear is, if I'm a worker and I'm using an ABN, I'm not an employee, right? So put differently, I must be a contractor if I'm using an ABN. Well, that's what businesses will say. So just going to go through a few dot points here to explain it. Now, the difference between an employee or a contractor at a sort of just a basic level, it's a really big difference. It really matters in terms of the rights and protections that you have as a worker. You might be doing a really similar role for example, as a contractor to a fellow worker who is just defined as an employee, but they're able to accrue annual leave and sick leave, long service leave, and various other entitlements. They're also able to get access to protection from, for example, minimum wages and rights to overtime for working, let's say, if they're full-time, over 38 hours a week. They also get other allowances and penalties within modern awards. Let's say they're working in the hospitality industry, for example. They get access to certain entitlements depending on when or how they work. The difference really matters, and it also goes to protections around when your work can be terminated, or when you can be given less hours and things like that. If you're a permanent employee, an employer can't sort of unilaterally vary the terms of your contract, whereas it becomes really difficult to dispute that type of scenario if you're a contractor. We can talk a bit more about that in a bit. So again, the context here is that independent contracting is really increasing in Australia across various industries. So it's not just increasing overall, it's over 1 million people are currently engaged as independent contractors, according to statistics from the Australian Bureau of Statistics. But it's also seeping into different industries. So it's not just, for example, in the gig industry with delivery drivers and Uber drivers and things like that. It happens in various industries now, such as aged care, disability care and support services, translation and interpreting. There's various different areas where it's become a really common way to engage a worker. And so what we're going to look at is sort of the big change that happened early last year, which has really impacted upon how we give advice in this space, is how the High Court decided a case in personnel contracting and JAMSEC. There are actually 2 cases, but they were decided together. We'll look at the changes a little bit. We have a very brief time today, but with this, the idea was that this has changed in a way, or clarified how a court is required to answer this question of whether a worker is an employee or whether they're a contractor. So prior to this decision, a lot of courts were applying what's called a multi-factor test. And so this meant that when they ask themselves this question, to answer it, they'd look not just at what the parties kind of agreed to when they started, what's it say in the contract? They'd also consider the totality of the relationship in order to determine its true character. What does that mean? I mean, that means that they're looking at various indicia or criteria, not just at the beginning of the contract, but also throughout the whole work relationship. They're looking at how much control did the engaging entity have? Did the person wear a uniform? Were they able to turn up when they wanted to, or for example, subcontract the work? And at the end, when they did this, it almost became a box ticking exercise. They would weigh up all the different criteria and then produce an answer. And so that's how it was done. And that often led to a lot of complication, but it also reflected the working reality, which was that people would get a contract, let's say a few years ago, that said they were a contractor, but then they were required to turn up every day to the same job, and they just missed out on all the benefits of an employee. So in reality, they were actually really an employee, but legally or technically in their contract, they weren't. So it did represent the reality for a lot of workers in Australia. But now the High Court's really clarified this and said that actually no, particularly where there's a written contract, the legal rights and obligations established in that contract are decisive of the character of the relationship. So the task that a court does, and what we would have to do if we're assisting clients, is we have to look at the terms of the contract at the time it was entered into by the parties, and really understand what is it that the parties agreed to. So the High Court's done this in a few other cases. We'll talk about one in a moment, where they're really focusing on employment being a contractual relationship and looking at what is in the contract itself. That's not to say that if you have a contract that said you're a contractor and you're paid by an ABN, that automatically means that you're a contractor. So this is where this myth is pervasive, and it's never easy to answer. So the High Court still requires that the terms in the contract, when you construe it, are clearly a contract as an independent contractor. So we call that difference a contract of service as a contractor, as opposed to a contract for service, which is as an employee or a worker within the business. And so with this, there's various things that the courts will look at. And so as one example, if we look at the cases themselves, personnel contracting in JAMSEC, personnel contracting was about a young fellow, a British backpacker, or that's what he was called in the media, and he was living in Australia, and he was engaged as a contractor to work on a building site. It was through a labour hire arrangement, which is relevant to the case, but it all boils down to the fact that he had a written independent contractor agreement. Both parties agreed that that was not a sham, and it had not been varied, so it was the contract to determine. And the High Court decided that, in fact, he was an employee. He was not an independent contractor. And that was because when you read through the actual terms of the contract, he had no ability to control his own work. He had no business of his own. He was required to turn up when they stated, and he had to do work within their business. So it's a good example where, although the test has changed, just because you have an ABN does not automatically mean you're a contractor, but the focus now is really condensed not to how you worked throughout your employment, but on what the contract itself says. So this is perhaps more straightforward, of course, if you have a written contract, but what about if there's just an oral contract? So many of our clients never signed a contract. They started in a very informal agreement, a verbal agreement, I'll do work for you. And then they're asked to get an ABN. So this is where it gets tricky. There's one case, it's a bit outside the scope of today's discussion, but there is one case in the federal court since that has said, a single justice that said that these new principles, or these principles in the High Court, do apply regardless of whether it's a written contract or an oral contract. So again, if we're helping clients to answer these types of questions, whether they have a written contract or an oral contract, we need to really be asking them questions around what is it that you initially agreed to, what were the sort of terms of that, and so that we can understand what it is that is the true legal relationship. It doesn't matter if it says employment agreement or contracting agreement, contracting agreement, because labeling doesn't matter. It has to be what the terms are. The focus there will be on control and whether the person's really working in their own business or the business of the engaging entity. Gets tricky, but hopefully that all makes sense so far. Now, the next dot point here that's come up is just about what if you're challenging the validity of the contract itself. So this wasn't relevant in the High Court case. Both parties in both cases accepted that those contracts that they had were the contracts and there'd been no variation, there was no sham. So the focus was on the terms of those contracts themselves. But the High Court really left the door open and said, none of this really applies, or at least it's very different if there's evidence to show that the parties varied the contract later on. So then you need to determine what happened in the variation, or whether there was a sham. So again, when we're talking to clients about this, we want to be thinking of, are there examples of variation later on? So asking about changes, and also sham, thinking about whether the relationship was misrepresented intentionally or recklessly by the business when they started. So I've spent quite a lot of time on this first myth, and that's because it's a big one. So I know we're going to have to jump on. So we'll just go to myth 2. So myth 2, this is again about determining a worker's status. So in this, it says casual employees who work regular shifts are permanent employees at law. This is often what clients say is, I'm engaged as a casual, I don't get leave, but I work 38 hours a week. Am I actually entitled to that leave as a permanent employee? So in effect, no, and we'll go through that. So it's really been cleared up in the last 2 years by some legislative reform and a High Court case as well. So casual employees regularly are rostered to work regular and systematic hours. They come and ask, can I get the benefits that my colleague next door to me who's full-time doing the same hours gets, leave? You would think the answer is yes, but actually it's not. And this is really unfortunate because casual employment continues to increase in Australia. We have among the highest rates of casual employment in the OECD. We have 23% of employees working casually, and we also have increasing labour hire arrangements, which really pushes casual employment into different industries. Casual employment often exists in industries where there's a higher incidence of women working as well, hospitality, retail, and various other industries. So big change here is again the High Court, but in 2021 in the Rosato case, they applied the similar idea that the contract is king, which is it's really, really important to focus on the terms of the contract. The decision in the High Court perhaps wasn't as impactful as it would have been because the federal government at the time, the Morrison government, introduced legislation where they, first time in the Fair Work Act, defined what a casual employee is. And so a casual employee is now an employee who does not have a firm advance commitment to ongoing work. So Section 15 capital A says that that has to be governed by the offer and the terms of the contract. So it doesn't matter how you actually work in practice afterwards, as long as there's a contract that clearly states that there's no firm advance commitment to work, then you'll be a casual employee. That's a fair bit of a change, and it went on from a different decision of Skeen in the full federal court, which applied a similar kind of multi-factor test where it looked at your whole employment period to determine whether you were casual or permanent. So now it's much clearer, and it's really difficult for some workers who've been working casually. One client yesterday had been for 15 years and working 38 hours a week. The law's really quite clear at the moment, but there is going to be some legislative reform in this space by the new federal government later this year. So watch this space. What there is, though, is that there's a broadened right this year to casual conversion that's now in the National Employment Standards. And so that means that if a person's worked casually for a long period of time on a regular basis, they can request to convert to full-time or part-time. Okay, so just, yes, okay, so we're just going to do a first quick quiz, whether a person's an employee or a contractor. So I'll just read this out, and then Bridget's going to put up the question and the poll. So Alex works delivering food and groceries for the online platform Deliverino on his e-bike. He works on average 5 days per week and often works in the evening when demand is higher. His hours vary, but on average he works 38 hours per week. Alex is allocated shifts via an app and can pick and choose which shifts to work. He is paid a flat rate of $20 per hour. So we'll just put up the question, which is Alex an employee or a contractor? And sorry, that's actually not a good question because it's asking for one different answer. It says yes or no. So if we, apologies for that. So if we put that an employee is yes and a contractor is no, if that makes sense. Just realize that doesn't make. Okay, so we've just got the answers through, and it's interesting to see that there's a bit of a split. So we have 19 people who answered, and 14 did say no, which is that they think that Alex is a contractor. 5 said I think he's an employee, and that's perhaps a good example of how there are differences here where it's not always an immediately obvious answer. On the current law, and applying the High Court's decision in personnel contracting, Alex would be a contractor, but we'd of course have to look to the terms of the specific contract he agreed to. There have been various cases run in both Fair Work Commission and also the courts challenging the structure of these e-delivery or platform gig economy platforms. So far, there haven't been any successful ones to challenge them being contractors. In the UK, for example, Uber has been found that it's an employment relationship, not one of contracting. And here we had Foodora, which has now left Australia because of the decision. They were found to be employees, not contractors, by the Fair Work Commission because they were forced to wear uniforms and could not choose their shifts. So it'll really depend on looking at the contract. But overall, I would say that he would be considered a contractor on this scenario right now. Okay, we're just going to go through. Thanks for answering, everyone. So myths about employee entitlements. The image probably suggests that at least the ATO would be interested in what this person does for work, or maybe the Australian Federal Police, but we will go to the myths. So if an employee is paid a salary, a modern award doesn't apply. This is a myth that many employers tell our clients, which is that because they're getting a flat annual salary, let's say 75,000, that any rates in the applicable modern award doesn't apply. So if they're covered by a certain award, there'll be entitlements to overtime, for example. And this is often where it most commonly comes up, is that a full-time employee does their 38 hours a week under their salary. They get paid the salary no matter how much overtime they do. And surprise, surprise, they're working a lot of overtime. So they want to know if they're entitled to that. So underpayment's a national issue. Last financial year, it was over 1.35 billion that was suspected to be underpaid. And the Fair Work Ombudsman recovered 532 million of that. Some of that was the businesses, large businesses, especially Woolworths, for example, self-reporting underpayments. But it's a really big ongoing issue. It speaks to some of the complexity in the award system, but also that there's intentional underpayment going on as well in some industries. So when we think of the awards system, there are 122 awards across almost every industry. There's just on a few days ago on the 1st of July, there was a 5.75 increase to all the minimum rates in the awards. And with this myth, rates and allowances in the awards do apply to an employee, regardless of whether they get a salary amount or not. It's really common for us to get a salary these days, as long as they're covered by the award. So if you're ever talking to a client who's just paid above the award, but they're working overtime, there's a good chance they might be being underpaid. And because the award rates go up every year on the 1st of July, and they've gone up really quite a lot at the moment because of inflation and things, it's really, it becomes likely that unless the employer's topping up their salary each year, that they might be being underpaid. So it's good to always check, is the person covered by an award? If they are, to determine their classification, and then to run a scenario of, well, if they worked 5 hours of overtime, in the last 3 weeks, are they still getting enough under their salary? So we'll just jump into another quick quiz. So the scenario is Lee is a full-time carpenter working in construction sites. He is covered by the Building and Construction General On-Site Award. Lee has worked for his employer for 6 months and is paid a flat rate of $45 per hour for a 38-hour week. In the last month, he's been working 5 hours extra each week, sorry, that's meant to say week, to finish a big project. He is not paid for the extra hours. Under the award, he is entitled to a minimum hourly rate of at least $26.18. The award also provides for overtime rates and other allowances. However, Lee's contract says that his hourly rate covers all entitlements. So I'll just give a moment because there's a couple of things there, but we'll put the question up. So the question is Lee entitled to be paid the overtime rate for the additional hours? All right, so we had 20 answers this time. Thank you, everyone. And 16 of the 20 answered yes, and 4 of the 20 answered no. So overall, I think most people there answered yes, and so that would be correct. But there's a few points there, especially when giving advice to clients, which is that we often have clients who are receiving quite a high hourly rate compared to the minimum rates they're entitled to in an award. Whether they have a contract or not, we need to consider the idea that overall, when if they're working overtime, is there actually an underpayment at all? So that's often a calculation exercise of looking at, the flat rate of 45 as against the 26.18 for the 38 hours a week. They'll have obviously quite a big surplus above the minimum rates in the award, and then working up whether the amount of overtime they're working at the overtime rate in the award, does it mean that they're still underpaid? And then if you think about certain things in contracts, there's often things called set-off provisions in contracts, which is that if you're owed something under one part of the contract, but you're being paid more, for example, under your salary, they can set off what they owe you by the extra amount they've paid you. So that can get tricky because it depends on the terms of the set-off, but ultimately I think here it's pretty unlikely that he'd have an underpayment given he has been working for a relatively short period of time. He's getting a high hourly rate of pay, and he's only been working overtime for 5 hours a week for the last month. So it's unlikely it is, but to answer that it is correct that he's entitled to those rates. It's just working out whether there's an underpayment. So we often do that, and in order to do that, we use the payment and calculations tool that the Fair Work Ombudsman has online, or we have our own spreadsheets for the awards. But that's the quickest way to use the payment and calculations tool. I'll have a link to that at the end if you're not familiar with that. Thanks for participating, everyone. All right, so we're jumping next onto myths about termination of employment. These are perhaps the most pervasive, and we deal with many people who have just been dismissed. So myth number 4, 3 strikes and you're out, or that an employer has to give you 3 warnings prior to dismissing you. Now that is not true. That continues to be a really pervasive myth, and it's simply not the case. There's nowhere in the Fair Work Act that specifically requires you to give 3 warnings, but the act of giving a warning is a relevant consideration that the Fair Work Commission will take into account if an employer dismisses a client, let's say, and they lodge an unfair dismissal claim. So under the Fair Work Act, Section 387 has a list of criteria, A through E, that the Fair Work Commission must consider when they're determining the harshness or whether a dismissal is unfair. And one of those goes to if the reason that the person's been dismissed is related to unsatisfactory performance, so as opposed to misconduct, then the Fair Work Commission will consider whether the employee was warned about that unsatisfactory performance prior to being dismissed. And so a warning must identify the aspect of performance that is of concern. So a mere exhortation to improve is not sufficient. So that means obviously it's a warning that needs to be about that specific thing. You're underperforming to achieve this KPI, or you're not doing this task correctly, rather than just generally saying, you're not really working up to standard these days. So it needs to be specific, and that often means it needs to be in writing. And then it also it needs to make clear that the employment is at risk unless the performance improves. Often there needs to be a bit of a nexus too. So a warning from 3 years ago is not going to be relevant to a dismissal today. So it needs to be a warning that's happened, in the not too distant past. Of course, no warnings are required where a person's dismissed for serious misconduct. That has a specific definition under the Fair Work laws in the regulations, but it includes sort of fraud or assault or more serious things that really damage the reputation of the business or the strike at the working relationship. There's also a different process for small business employers. That's called the Small Business Fair Dismissal Code. If you're not familiar with that, the Fair Work Commission website has a good information about it. It's basically a checklist that businesses that have less than 15 employees have to comply with when they dismiss an employee, and it's a lot less onerous than the requirements under 387 for other employers with more than 15 or more employees. So going on to the next myth, an employee can be dismissed for any reason within their probation period. This is perhaps a myth that employers think is the case. And so some things to consider here is that, of course, that's not correct. But why it comes up is that the main protection for most employees in Australia is unfair dismissal, particularly at the Fair Work Commission. And with that, you can only make an unfair dismissal if you've been employed for at least 6 months. So often employers think that they have just a free card to dismiss employees within those 6 months, as long as their contract says there's a probation period. And really, it depends on what rights the employee has within that period. So before 6 months, an employee can't make an unfair dismissal claim, but then there comes this distinction between the reasons for dismissal that are unfair or unlawful. Now, unfair reasons, they can't make the claim, the employee, in that time frame. But if it's for an unlawful reason, then an employee may very well have protections under the general protections or under anti-discrimination pathways to dispute the termination. So you could have been working for 1 day, or you could even be a prospective employee applying for a job to be protected from the under general protections and make a claim to the Fair Work Commission. And anti-discrimination doesn't require any minimum employment period, state or federal. So just to consider those, and that's again about asking the client, what were the reasons given to you for the dismissal? Thinking too about the difference between federal kind of system employees, which is most employees, and then states. So where as legal aid employees, state government employees technically, and local council, state public sector employees, as we're known, we're covered not by the Fair Work Act, but by the Industrial Relations Act in New South Wales. And there are some provisions under there to extend a probation period. That's just very specific, though, to sort of government sector employees. So we'll move on now to myth 6. Now, often clients have really unrealistic expectations around what will happen when they get their when they make an unfair dismissal case if they win. So an employer will get their job back or their full loss pay if they win. And I think this is just an important one to have clear advice about with clients to manage expectations. So it's very common, as I said, they have unrealistic expectations. And that's because a lot of clients think that when they're dismissed, they're going to get full compensation from the date they were dismissed all the way until the outcome. And some people ask for 1 year's pay, for example, or they want their job back plus pay. And so the Fair Work Commission is empowered to order compensation or reinstatement back into a job. But if we look at the statistics from the last financial year, the reality is really that unfair dismissals are worth very little, and it's very rare that people get reinstated. So under 1% of all applications got the full 26 weeks compensation. So 6 months or 26 weeks is the compensation cap that the Fair Work Commission can order. And the average of all compensation was about $8,500 last financial year. So that's not a huge amount of money given how much effort has to go into an unfair dismissal. Reinstatement's even less than 1%. Then there's some other criteria to consider. So even if an employee applicant is successful in an unfair dismissal claim, the Fair Work Commission, if they decide to order compensation, still has to consider the following criteria under Section 392 of the Fair Work Act. And some of the ones that really come up a lot for clients are particularly where they've already earned other compensation in the meantime or remuneration. That might be from, for example, if they're on workers' compensation, receiving pay while they're disputing the unfair dismissal, or they've gone and got another job. In either of those scenarios, they will have any of those amounts they've earned taken out of any compensation that the Fair Work Commission orders. So in some scenarios for clients, that might mean if they've had 100% of their pay the whole time, they might win the case and get ordered $0. So you have to really be understanding what the client's received in the meantime, whether they've taken efforts to mitigate the loss, have they looked for other jobs, and did they even have capacity to work in the meantime, or were they injured? Was there misconduct as part of the reasons? That will often reduce the amount by a percentage. So often these are the things that we talk a lot about with clients to manage expectations. So we'll just move on. And this is the last quick quiz. We're asking, is this client protected from unfair dismissal? So sorry, there's quite a wall of text here, and I'll just read it out. Sophia is employed as a full-time retail assistant with J-Mart, a large nationwide retail store. Sophia's employment is covered by the Retail Industry Award. She has a contract of employment which states she has a 6-month probation period. Sophia commenced in her role on the 4th of February 2023, just over 6 months ago. In February 2023, she was 5 minutes late to work and received a verbal warning, but has had no other issues. In May, she took unpaid leave for the whole month to look after a sick family member. When she returned, her manager made several remarks about her being lazy and not committed to work. This made Sophia feel she was being targeted and bullied. Yesterday, Sophia told her manager she'd contact Fair Work to inquire about her legal rights. Today, Sophia received a termination letter stating that she was dismissed due to persistent lateness and poor performance. The question is she protected from unfair dismissal or eligible to lodge an unfair dismissal claim? Okay, 21 this time. So 19 of 21 have said yes. 2 of 21 have said no. Well, I've probably been a bit cheeky here and thrown in a slight curveball. And so the answer technically is no. And I will just explain why. And this is a good example of some of the things we have to check to determine whether a person is protected from unfair dismissal. So when we think about the minimum employment period, of course, I mentioned in the previous slide that the minimum employment period is 6 months. That's if you've worked for a normal business, like not a small business, so a business with 15 or more employees. And so if you've worked for them, you have to be employed for 6 months. But there are periods of time where that won't be counted towards that total period of service with the employer. And one of those is unpaid leave. So when she took that time off for the whole month of May, she actually didn't, that means she only worked for 5 months when they're counting the total employment period. So sorry, I threw that in as a bit of a curveball, but otherwise, if she hadn't taken that, then she would have just been eligible. But what we can think about in her case is that she may have not a very strong claim, but she may have evidence to support a general protections claim, because under the Fair Work Act and section 340 to 342, she has protections to make if she's able to make a complaint or an inquiry in relation to her employment. The employer can't take adverse action against her, which includes dismissal, because she made that inquiry. So when she said she was inquiring about her rights to fair work, she then got dismissed the next day, albeit for a different reason. There's an inference there that she was dismissed not because she was late, because that happened ages ago, but actually because she made the complaint. She'd need to have some good evidence to show causation, the connection between the two events, but that might be a pathway for her because she took that leave. She's not able to make an unfair dismissal claim. So that's a common scenario we talk to clients about. And with when you've been dismissed and you're making a general protections complaint, it's got the same really short time limit to make the complaint as an unfair dismissal, which is 21 days from the date the dismissal happened. And it's to the Fair Work Commission. So that's one. And so we're just going to jump on, and thanks so much everyone for participating and answering. So now just thinking of a summary. So in terms of sort of the kind of high level summary of what the relevant issues are, is that, you know, with those big high court cases, the character of the work relationship really does depend on the legal rights and obligations established in the contract. It's unless there's evidence of a sham or a variation. There's lots of information, helpful information on the Fair Work Ombudsman website about these big changes and how to sort of look for the relevant things with a client. So good to talk to those. If you do have any questions, of course, please contact our team. We'll have our information up shortly. As to casual employment, essentially it's casual unless you can show evidence that there was a firm advance commitment to ongoing work. So again, looking at what the contract or the agreement says, and in the absence of an explicit agreement, it's going to be quite hard to show it was something other than casual. But again, legislative reform is coming up soon, so that's good. With pay, always consider award coverage. So you can look at clause 4 of every award, and they're all on the Fair Work Ombudsman website. That is the coverage clause, and it tells you who's covered and who's not. And then think about some of the industry specific rates and allowances that are in the award if it covers a client or a person, and then compare those against the salary. And a good tool to use to do that comparison is the payments and calculations tool that the Fair Work Ombudsman has on their website. And with protections from unfair dismissal, they're the most common type of application. They're really well known, especially by clients, but they're not always available, and often they have really limited remedies. So it might not be the best pathway for a client. It just depends on what's happened, what the reasons were for their dismissal, and whether they're eligible. So just going to some useful tools and referrals before we turn over to some question time. So just with, again, I talked about the payment and calculations tool. We'll send out an email at the end of this with links, but if you're not familiar with that, the pact is really quite good. It has its limitations, but to get an initial understanding of what an underpayment might be for a client, if you want to do a sample of a fortnight payslip and work out if they're being paid correctly, it's a good tool to use. If you aren't able to give them legal help and you need to refer them elsewhere, there's a couple of places. The Fair Work Commission has a really good page on their website with a directory of legal services. It's called Where to Find Legal Help. Our service is one of those services there. And then if you do have clients who have really serious exploitation issues, including modern slavery or serious underpayments, particularly with migrant workers, the Red Cross has actually just launched a really great initiative. It's a directory called the Work Right Hub, and that's on their website. We'll send that link out. And we've been in discussions with them about us being one of the referral pathways there for underpayment cases. So that's a really good new resource available. And then just referrals to our service, even if you have a question, this is our email address for our team. We're really, excited that people were interested in today's talk and coming from various different parts of the community legal services sector. So if you have a client you want to talk about or refer, please get in touch with us through that email. Okay, so that's the end of the presentation. Sorry, I sort of had started off and went into depth on one myth and then had to rush the others. So I hope it wasn't too fast and that it all made sense. So if anyone has any questions, please feel free to put them in the chat or just to ask them out loud.
Actually, people can't ask them out loud.
Oh, sorry, you can't ask it out loud.
No,
sorry.
it's not a feature that we have.
Sorry,
but we welcome any
questions. Okay.
Thanks so much, Giles. It was great having exploring those myths, and I feel like I learned a lot. So we have a question.
Ooh,
what is a constructive dismissal?
That is a good question, Kevin. So in the context of an unfair dismissal case, it's often argued that the starting point has to be that you have to show that the dismissal was at the initiative of the employer. So essentially that the employer took some positive act to end the employment relationship. And that becomes really straightforward, where you have a termination letter that says you're dismissed. But there are scenarios beyond that that also become a dismissal, and these are known as constructive dismissals, and they include where there's a forced resignation, or a heat of the moment resignation can sometimes be that, and that is where a person is given no other real choice but to resign. So they resign not because they want to, but because they have to. And that can count as a constructive dismissal. The other heat of the moment resignation is if a person, is in a heated debate with their manager and they say, I'm out of here, I've had enough, and they leave, and then receive an email later that day saying, we accept your resignation, that won't be sufficient to be a real resignation. There are various cases at the Fair Work Commission that will say employers often need to, check in and just confirm that the person did actually want to resign before accepting it in a heat of the moment scenario. So there's some examples. There are other examples with repudiation of the contract, which is where an employer might essentially breach an essential term of the contract and show that they no longer want to be bound by the terms of the contract. And if that happens, an employee can then choose to accept that repudiation by resigning, but then they'd have potentially grounds for recovery of compensation through constructive dismissal. That's something we could talk about for ages, but probably a bit beyond the scope of today. But I hope that answered your question. So James asked, if international student or people have no working visa, are they protected by Australian law? That's a really good question. And there's been some recent changes in that space. I'm not 100% across them, but essentially the federal government has just currently, there's been some legislation that's gone through. I'm not sure if it's actually, if it's sort of in action at the moment, but it's meant to say that if a person was working without a visa at a certain time, that doesn't prevent them from being able to take legal action to recover what they're owed. So previously there was nothing like that, and the real risk for so many people was if they, and maybe just a common example we dealt with was people who were in Australia on student visas, especially before the pandemic. There was and there's going to be a return to this, which is a limit of working 20 hours a week, and lots of people were working beyond that limit, and so then they were being underpaid on all those hours, and they wanted to recover the unpaid wages. But the risk was, of course, if they came forward, would they have problems for their visa and risk being deported at the most serious end? And there was really no clear protections there other than the department at the time of immigration, now Home Affairs, saying, we will try and work with the Fair Work Ombudsman to not have negative impacts on migrant workers who make complaints. But now there's clearer laws saying that can't happen. Again, I'm not 100% across it, but I think that's becoming, more protections in that space.
Thanks, Giles. It looks like that's
Okay.
all the questions that we've had, and some thank yous.
Oh, great.
Coming
Thanks so much,
through.
Krista. Thank you.
Just to let people know too, that if anything occurs to you after the webinar, you can send an email to sealy-webinars@legal-aid.newsouthwales.gov.au. And I didn't say at the start of the webinar, but all our webinars are recorded, and this will be uploaded to Legal Aid's YouTube channel following the webinar today. And for anybody who would like to, you can subscribe to YouTube, and you can also subscribe to our Law for Community Worker podcast, and to receive alerts about upcoming webinars and podcasts as well from the Legal Aid website. So feel free to do that so that you can stay up to date with what's coming up. And I'll just say a big thank you to Giles for the great, clear presentation today. And thanks you to everybody for attending. and we'll end the webinar now.
Thanks everyone for participating and being part of today.
Bye, everybody.
Bye. Thanks, Bridget. Bye.
Thanks, Giles.